In this talk, I am going to be discussing claims of victimisation arising out of steps taken in litigation. Please use the pause button to pause a slide to read in further detail. Can a claim of victimisation be mounted on the basis of something done in the course of the litigation by an opposing party? When will an assertion of judicial proceedings immunity defeat it? What else will defeat it? A number of us have come across a scenario in which this has arisen or could arise. Two parties are engaged in litigation, and one party takes a step in the litigation, such as issuing a costs warning, declining to give early disclosure, proofing a witness, notifying others of the outcome of a hearing, or making a costs application. The other party then responds by applying to amend their current claim or presenting a new claim to add a wholly new complaint of victimisation, relying on the step taken in the litigation as the detriment. The question for advisers then is whether this is a respectable claim or whether it's amenable to strikeout. To determine this, we must first look at the governing principles. There are three relevant principles to consider. The first is the general principle that no wrong should be without a remedy, and related to this, that there is a public interest in allowing claims of victimisation and discrimination to proceed. The second is the definition of victimisation contained at Section 27 of the Equality Act. And the third is the principle of judicial proceedings immunity, at its core meaning that no action shall lie in respect of evidence given by others in the course of court proceedings. The rationale underlying JPI is that those engaged in litigation should be able to speak freely without fear of civil liability, and further, that there is a desire to avoid a multiplicity of actions where a future court is required to determine the truth of the evidence given in earlier proceedings. These two principles are explained in two different lines of authorities which ultimately dovetail together. In 2001, the House of Lords ruled on the case of Darker against West Midlands Police, a claim against the police following the staying of criminal proceedings as an abuse of process. It was alleged that false evidence had been given by police officers. The House of Lords held that the JPI principle covered the giving of witness evidence in statements and in the witness box. However, JPI was not wide enough to cover the fabrication of evidence preparatory to its inclusion in witness statements. The House of Lords plainly had it in mind that it was necessary to balance the desirability of preventing witnesses from being vexed with satellite claims with the public interest in not allowing the principle of JPI itself to allow abuses to take place. Accordingly, a distinction was drawn between what a witness stated in court, or what he said in proof he would say in court, and evidence that had been fabricated. In the same year, the House of Lords gave judgment in Khan and the Chief Constable of West Yorkshire Police, one of the seminal cases on the meaning of, on the grounds of, or because of, for the purpose of direct discrimination and victimisation claims. The Chief Constable's refusal to provide the reference in question was done to protect his position in the ongoing litigation. Lord Nichols said that employers acting honestly and reasonably ought to be able to take steps to preserve their position without laying themselves open to a charge of victimisation. The refusal to provide the reference was a reasonable thing to do in the litigation, and as such did not constitute an act of victimisation. The following year, in the case of Zaiwalla and Walia, the EAT considered a case of sex discrimination brought by a trainee solicitor. The Employment Tribunal in that case had upheld her claim and had awarded, among other things, aggravated damages. the award of aggravated damages being made at least in part because of what the ET had described as the respondent's monumental effort to defend the proceedings of the most inappropriate kind. The ET had observed that the respondent had attacked the claimant in relation to her personal standards of professional conduct and had levelled at her a series of threats which would be daunting to any individual, let alone to someone about to embark on a legal career having difficulty obtaining a training contract. The defence of the proceedings was deliberately designed by the respondents to be intimidatory and cause the maximum unease and distress to the applicant. The EAT dismissed the appeal, including against aggravated damages. It was not contended in that case, however, that JPI applied. 2 years later, the Court of Appeal considered the case of Heath against the Commissioner of the Police of the Metropolis, a claim by a female civilian officer about the treatment of her in a disciplinary hearing convened to determine her complaint of sexual harassment against another officer. The Court of Appeal held that the disciplinary board was quasi-judicial, and accordingly the principle of JPI applied to its acts and no action could lie against it. The Court of Appeal said, JPI attaches to anything said or done by anybody in the course of judicial proceedings, whatever the nature of the claim made, except for, and then listed some exceptions. Going on to describe JPI as a core immunity, the Court of Appeal then went on to say that it applies to all forms of collateral action, however worthy and however much it may be in the public interest to ventilate it. Discrimination claims were important, but no more important than any other type of claim. Even as this was said, however, this did appear to be unduly wide. It failed to acknowledge, for example, the fact that the immunity from liability and negligence given to advocates had been eroded and indeed finally abolished in the case of Arthur J.S. Hall and Simons in 2002. It followed that that statement of principle was vulnerable to further revision. In St Helens Borough Council and Derbyshire, the claimants, some 470 female employees, had presented a claim for equal pay. Before the claims were due to be heard, they received correspondence from the employer, which the ET found spelt out a danger that if they persisted, children might be deprived of school dinners and there might be redundancies. The ET found that the correspondence was victimisation. In due course, the Court of Appeal reversed that finding and the claimants appealed to the House of Lords. The House of Lords held that there was a striking and obvious difference between the current case and the case of Khan and West Yorkshire Police. In this case, the object of the act complained of had been to put pressure on the claimants to settle their claims. There was no such object in view in Khan. Lord Hope said that while the ET had not said in so many words that it addressed itself to the further question whether the correspondence was correspondence which, as Lord Nichols had said in Khan, was a step that an employer acting honestly and reasonably ought to be able to take to preserve its position without laying itself open to a charge of victimisation, that was, in essence, the point which the ET had made. He went on to say that when the reasons were read as a whole, it was plain that the ET was of the opinion that the conduct in question, while no doubt honest, could not be said to be reasonable. It went further than was reasonable as a means of protecting the employer's interests in the existing litigation. The following year, the Court of Appeal gave judgment in another victimisation claim, Bird against Sylvester, which went the other way. In this case, the claim for victimisation arose out of the issue of a costs application and threat of disciplinary proceedings following the dismissal of an earlier claim. The Court of Appeal ruled that the reasonable employee would not have concluded that the employer's stance on costs went beyond what was reasonable. Accordingly, it did not constitute victimisation. The position then on steps taken outside the giving of evidence seemed settled. The question was whether the reasonable claimant would consider that the act complained of went beyond what was reasonable. Returning to the giving of evidence itself, in Parmar there was a brave attempt to contend that passages contained in witness statements constituted victimisation. Mr Justice Underhill, as he then was, gave that contention short shrift. He said, "The present case illustrates how unsatisfactory the position would be if the immunity did not apply. It would in many cases be all too easy for claimants who had failed in their primary claims, for whatever reason, to resurrect the allegations made in them by way of collateral proceedings." It was also contended in that case, on behalf of the claimant, that the earlier case of Zaiwalla and Walia was authority for the proposition that JPI did not apply to discrimination claims at all. Mr Justice Underhill said that in that case, the question of JPI had simply not been before the tribunal, and further that Heath had not been decided. Accordingly, Zaiwalla could not be used as an authority to derogate from or qualify Heath. In Singh and Moorlands Primary School, a slightly different claim was mounted. The claimant alleged that the council's attempting to put undue pressure on a witness to give untruthful evidence, she alleged, amounted to a breach of the implied term of mutual trust and confidence. The defence of JPI was mounted. The Court of Appeal said that the giving of evidence was covered by JPI. However, the placing of a witness under undue pressure to give untruthful evidence, as was alleged, was not. The rationale of the immunity was to ensure that persons who may be witnesses would not be deterred from giving evidence by the fear of being sued. The immunity also covered statements of case or pleadings. It was extended only to that which was necessary to prevent the core immunity being outflanked. And what was necessary in this context meant what was practically necessary to prevent the core immunity from being outflanked. In this case, it was not necessary to prevent the core immunity from being outflanked. The act in question was not covered by the principle of JPI, and the principle that a wrong should not be without a remedy prevailed. The next case, P against the Commissioner of the Police of the Metropolis, concerned a quasi-judicial body and therefore returned to the statement of principle enunciated in Heath. In P, the claimant had previously suffered an assault which had resulted in PTSD. In due course, there was an incident which led to her arrest. A charge of misconduct was brought against her. She asserted that her behaviour on the occasion in question was related to her PTSD, but she was dismissed without notice. She presented a claim of disability discrimination based on the acts of the police disciplinary panel. Applying Heath, the claim was struck out and the strikeout upheld in the EAT and the Court of Appeal. The claimant appealed to the Supreme Court. The Supreme Court held that the Framework Directive conferred on all persons a directly effective right to be treated in accordance with the principle of equal treatment in relation to employment and working conditions, and further the principle of equivalence meant that police officers had to have the right to bring claims of treatment contrary to the Framework Directive. This could not be derogated from as being a matter within the national margin of appreciation. Accordingly, if there were created a statutory process which entrusted disciplinary functions to a body which arguably had judicial immunity, that could not be allowed to prevent an officer from contending that the disciplinary body had acted contrary to the Framework Directive. In turn, the national rule of JPI had to be disapplied. Most recently, An EAT case in 2019 illustrates the application of JPI to the giving of evidence in judicial proceedings. Aston against Marlet was a claim about an individual who'd been dismissed after a long-term sickness absence. There was a dispute about the effective date of termination. This was determined at a PH. During the PH, a witness for the employer referred to a goodwill payment of £4,000 which had been offered to the employee at the time of dismissal and then withdrawn. In the witness box, the offer was made again. However, in subsequent correspondence, the employer described that offer as being conditional on the employee withdrawing his claims. The employee amended his claim to claim victimisation. It was held that no action could be founded on the evidence given in the witness box. It was protected by JPI. Further, although Heath was no longer good law following P, the discussion in Parmar on the applicability of JPI remained good law. The giving of evidence by a witness in the course of a judicial hearing is, of course, incontrovertibly, in principle, a context to which the immunity applies. In summary, therefore, the current position is as follows. JPI applies to evidence given in judicial proceedings. Outside evidence given, a step taken in such proceedings will not constitute victimisation if it goes no further than is reasonable to protect the employer's position in the proceedings. A quasi-judicial body carrying out work-related functions may not be protected by JPI if that would deprive a claimant of a remedy to which he or she would otherwise be entitled under the Framework Directive. Finally, however, this latter position could be susceptible to change. Provisions under the EU Withdrawal Agreement Act 2020, not yet in force, give power to ministers to make regulations disapplying EU case law and disapplying domestic case law relating to EU case law. The consequence, of course, is that subject to these provisions coming into force and regulations being made thereunder, arguably P could be disapplied. Thank you for your attention. I will be delighted to hear from you with any questions arising from the content of this talk. Please email me on my Chambers address or contact my clerks, Gary Carney or Janita Patel.